I think we're good to go here. So good evening. Good, I did. All right. That's there. Never mind. All right. It is Wednesday, October 18th, regular meeting of the Programs and Services Committee. We are being audio and video recorded. Present at the beginning of the meeting from Ward 1, Councilor Maria Greenberg. From Ward 2, President Susan Albright. From Ward 5, Councilor Bill Humphrey. And I am Josh Gruntzman, Chair of the committee, Councilor at Large from Ward 4. We may be joined by other members of the committee. Not sure. I know a couple of them said they couldn't make it. Mr. Ciccarello, good evening. Mr. Temple, good evening. Katie, good evening.
Hello.
Thank you all for joining us. We have two meetings on our agenda. Two items on our agenda, and we'll take them together. So let me read them into the record. First item is item 314-23, a discussion and possible creation of an ordinance regarding vibration control measures. Second item is item 88-22, a request for a study on construction vibration standards. We did have a bunch of materials presented to us, which were super helpful. Who is going to talk to us about this?
I can kick us off and we'll probably phone a friend, Anthony and Jonah. So I will share my screen. I do have just 4 slides that we can kind of go through if I'm allowed to share the screen.
That would be great. I just want to ask before we go, Anthony, for lack of a better term, it's pronounced Ciccarello, correct?
Correct.
Okay, because I've heard a sort of a bunch of different things and what I would call bastardizations of the name. And I think
Story
it's
of my
Ciccarello,
life.
so I want to make sure we got it straight. People always get my name, you know, Princeton,
Thank
Christmas,
you.
Princeton. So
Okay.
anyway, I'm sorry. Ms. Wheelo, go ahead.
No worries. It's an important thing to get right. So let's see.
And before you get started, I will say that we've been joined by another committee member, Councilor Pam Wright from Ward 3.
Okay, hold on. Okay, so we do have the 2 docket items, 88-22 and 314-23. They both have some considerable overlap with, vibration control, mitigation. So just to give an overview of, how this has evolved. So around June 2021, is when it was started to be discussed as perhaps a control on special permits for impacts to neighbors on vibration. So a condition was crafted and was implemented on select projects from about December 2021 to March 2022, and even after that there were some projects that it was placed upon. When sort of deciding when to use this condition, we asked for further direction from the Land Use Committee as part of a general discussion on standard conditions. We have a whole slew of them on all aspects of a special permit. It was then sort of the direction was to only add the mitigation fund of $100,000 to projects with 25 plus units. However, since then, there were a few projects that came in to seek an amendment for their special permit to get this condition modified or removed. We then Jonah and I have mainly been the ones kind of not supporting this, but doing a lot of the administrative work on this. So we consulted with engineering, Lou Taverna, planning with Barney, myself, public buildings, Josh Morse, law with Jonah, and Anthony in inspectional services to sort of get a better idea of the repercussions of this condition. Is this reasonable? Is there a better way we could be doing this? So we did find we did sort of come to the conclusion that perhaps an ordinance is the way to go on this, because it would then be extended to both as of right and special permit projects, because there are even by right 2 families or single families that have caused impacts to neighboring properties. So the prior special permit condition was a bit flawed in that it only applied to special permits. It didn't capture as of right construction. A one-size-fits-all approach didn't really take into account the specifics of the site, the topography, any, underlying, geology of the site. Oops. And it was largely based off of state blasting regulations and had this mitigation fund tied to it, which then at building permit caused issues with developments sort of saying, this isn't reasonable. We'd have to go back and forth. And like I said, 3 projects came back to alter that. So in the proposed ordinance, which there is actually a more up-to-date version than the one that was in the packet, which it's sort of is enacted when there's demo or a building permit for construction activities that require, driving piles or piers, removal or alteration of ledge, soil reinforcement, or compaction by vibratory roller. This next sentence is different than what was in the packet. It's sort of more, and that was on the recommendation of Commissioner Morse. It also requires a licensed and insured geotechnical professional to evaluate the methods of construction and the unique site conditions. It would apply.
I'm sorry, Ms. Wheel, can you just explain again how that sentence is different than what was in the packet?
So it sort of, I think it stopped after vibratory roller. However, this is giving some exceptions to that. So I think a lot of construction uses vibratory rollers to, roll out a patio or just a smaller area of land than perhaps, a single family and above. So it's sort of specifying landscaping work, sidewalks, driveways, retaining walls, as well as accessory buildings under 700 square feet.
Okay, maybe we'll go around in committee and we'll just all talk about how we independently use our respective vibratory rollers, but for now this is good. Okay, go ahead.
And then sorry, the Zoom is covering that last piece. So on special permit projects, if it is a large project or there are known concerns regarding the area of the city that this project is based in, the city council does have flexibility to incorporate additional measures such as that mitigation fund if they deem appropriate. So lastly, lastly, these are the sort of main changes of that revised ordinance, and I can share the Word document too if at all helpful tonight. So it alters that first section of A with the vibratory roller. It just sort of expands and gives some flexibility on smaller projects that require compaction. And it also added section B, which allows an alternative to the plan set forth if the applicant submits a signed and stamped letter from a licensed and insured geotechnical consultant. So that was also, I believe, a recommendation from Commissioner Morse. So that sort of concludes what I have and can open up to discussion. Just want to make sure Jonah or Anthony, if you have anything to add, you can jump in.
I don't have anything to add right now, Kitty. Thanks.
Yeah, I don't have much either. I think just to reiterate that, we've learned a lot of lessons from going through the vibration control through 2 years at the special permit process. And really our biggest takeaway is a one size fits all approach, which was our vibration control condition at land use, just doesn't seem to be working and isn't appropriate because we just simply don't know all of the construction means and methods. And we also aren't experts in this area. And really nobody in the city is. So the goal with the ordinance is to really turn it back onto the developers and their professionals to certify and determine the most appropriate course.
That's great, thank you. I will mention that we've been joined by Councilor Lyle Baker from Ward 7, or at least a Zoom user identifying as Lyle Baker. Committee members, in terms of process, I just want to point out or sort of call attention to the fact that when we make, in particular, ordinance changes, it's really helpful for us to have the ordinance language. That's something that both the administration and the legal department have agreed to help us work through and to provide us that language as we go through these. So I think it's really helpful that there was information provided in the packet. Katie, I think we will, if it's okay with you, take you up on the offer to put the Word document up at the appropriate time, especially committee members, if we're going to do this, excuse me, in one meeting. I think it's appropriate for us to have the language and know exactly what we're approving. Avoids misinterpretations and confusion down the road. So thanks to everyone for all your excellent work and the preparation on this item. President Albright.
Thank you, Mr. Chair. So I first have to say thank you to Mr. Temple and all the others who were involved in the creation of this ordinance. I think I first became involved with this, I don't know how many years ago. I think it was TRIO, but maybe it was, I don't remember which project it was. But there are neighbors to various special permit projects that wish that we had had a vibration ordinance some time ago. And I know that I discussed this early on with Mr. Temple, and we went to meetings with specialists. I think you were at one of the meetings that we had. We called in a guy from, was it Montreal? No, it was Toronto. I forget, Montreal or Toronto. They'd had a vibration ordinance for a long time, and we talked about the pros and cons of it. So I'm really glad that we're in this place now. I sent the ordinance to the committee that I worked with back in the day that were involved with both projects on the north side. And they gave me some comments that they wanted me to raise. First was notification to abutters. There's no mention in there about notification to abutters if this is happening. The second thing is there's no standards reference. It depends on, you can go out and hire Joe Schmo geotechnical guy, and he's going to say, oh, no problem here. And who's going to know? There's no standard referenced as to what the geotechnical work has to be based on. There's no reference to historic properties. And from all the research that we did back in the day, we know that historic properties are more at risk than newer properties, and there are very people would put in place if they, and there are standards actually that are discussed in the literature about how to deal with historic properties. And finally, there's no, I don't remember, maybe there is something there about damages and remediation. How do we make sure that if there are damages and there needs to be remediation, that happens? There's talk about enforcement, but I'm not sure what that really talks about. So, Mr. Temple or anybody else, please
Yeah.
help.
Yeah,
like
let
to-
me try and
a few
address
questions there.
a few of those, if that's all right. I think on the enforcement piece of it, starting at the end, it's a private right of action. I mean, the city isn't going to step in and kind of act as a judicial system between neighbors and abutters here, just like any other type of private dispute where a property owner is creating damage to their neighbor. There's a right and a cause of action to address that. I mean, our ordinance is trying to put into place a requirement that there are a certain level of controls to avoid it. But if it happens, the city isn't gonna take responsibility or be responsible for the remediation of that. That's just not possible.
So is there a requirement that if it is deemed that there could be vibration damage, the abutters are notified of the results of the vibration studies?
Yeah, I mean, that's really what 1 and 2 are as the key points of this. The geotechnical engineer will need to create a vibration control plan and then make a determination as to the scope of the pre-construction surveys and the scope of the properties that are within an area of risk. And then they'll need to notify those properties and do pre-construction surveys and give us proof of that.
And give them the results of because vibration studies happen during construction. So do they have to give the results of the vibration study to the abutters?
I'm sorry, can you repeat that?
Yes, during construction, you have the vibration control happening. The vibration studies will happen during construction. Are they required to give the abutters the results of the vibration studies?
So my understanding is we're talking about pre-construction and post-construction surveys.
Yes.
The monitoring and the implementation of what they do during construction, that's determined by their geotechnical engineer.
So then the abutter just says after construction, they say we have damage
Right.
and
Well,
and-
they'll have a post-construction survey and a pre-construction survey to use it as part of their claim,
yeah,
assuming that they were within the scope of range determined to get the survey.
right. They would get the survey, they would get the results of the survey.
Yes.
I think at
That's
least the way I
fine.
read it, the ordinance seems to indicate that proof that a survey was done is provided, not necessarily a copy of the survey or what I think President Albright's talking about.
Yeah, yes, I understand what you're saying. I mean, I believe it's common practice in the industry that if you're doing a survey of the property, you're going to give them a copy of it. But we could certainly add that in. I'd want to run it by our internal team on this, but that seems reasonable to me to say,
That a copy of the
copies of
survey
the
was offered.
pre-construction surveys are provided to the property owners.
Yeah, that's good, but I really was talking about the vibration measurements that happen during construction.
Right.
The
No,
neighborhood that-
I understand that, President Albright. I think though, really the point of this ordinance is the city isn't going to oversee this. It's got to be up to the professionals hired by the developers, just like almost every other area of construction. We are not overseeing every little piece of this, right? They all, in every other area of the industry, they're hiring people and we're just doing inspections. So it really needs to be put on them. And I know, we say they can hire any Joe Schmo, but a licensed geotechnical engineer in Massachusetts means something, and they're going to put their stamp on it. So we need to be able to trust that.
So the action, if there's any action required, it happens between the abutter and the construction people.
So long as it's in accordance with our ordinance. If they're violating our ordinance by not submitting what they need to, then we would take action.
What about the issue of standards? We have,
For the
I think that's up to the professional. And I think that was one of the kind of missteps with our special permit condition. And me and you worked closely on this, right? And we came up with a standard, but it really wasn't the industry standard. It was just something we picked, and it was somewhat arbitrary and it seemed like a good number. But we've gotten a lot of pushback from it, and talking to our team internally and talking to Josh in how we handle school projects and other city projects, it didn't make sense. It wasn't a number. They weren't numbers he would ever go by.
there are industry standards out there. And there are, I'm not sure that the historical properties is a standard, but there are discussions about the fact that historical properties need a different standard.
But again, we're trying to just take a general approach, and the whole point is that the geotechnical engineer will make an assessment based on the unique properties of the property, I guess.
So we're sort of take hands off, it's up to you to figure out what the standards are.
Right, just kind of like means and methods of construction.
And I might beg to differ on the fact that of properties of historic value that for example, if it's a landmark property.
I don't think a landmark property would be doing the type of work that triggers the vibration ordinance. Maybe I'm wrong, but
No, not the landmark property, but the landmark property could be abutted by the property that's doing the construction. And the landmark property could be affected by the property that's doing the construction. So, yet there's no standard that makes it more, a higher standard for the historic property that's abutting it.
yeah, I mean, I think we're kind of getting out of my realm here, and maybe this is part of the point that the city doesn't have expertise in this area. But I don't know if a landmark property is any more susceptible to damage necessarily.
Oh, there's
Again,
definitely stuff in the literature about historic properties being more susceptible to vibration.
well, then that would and should be something the geotechnical engineers take into consideration, perhaps.
Well, if it's not even mentioned in our ordinance, then they can, I don't want to say get away with murder, but they could.
No, I understand that. I mean, I have to say this ordinance would be the first of its kind in the state. I mean, nobody is really regulating this at all. So just the fact that we're even wading into these waters is pretty significant to really go beyond and create our own standards without employing our own geotechnical engineer is really impossible.
Okay, I'll leave at the moment.
President Albright, I thought you were asking about sort of qualifications for the geotechnical consultant. Is that
That
not what
too.
you're asking?
That too.
Okay,
But
do we,
I understand now that you, in order to be a geotechnical consultant, you have to be licensed as that. Is that correct?
there's a state licensing,
That's my understanding, Anthony. Can you confirm that?
I can confirm that, yes, you would have to be licensed to be a
what is,
geotech.
do you know what is that the license, a geotechnical consultant?
It's a professional engineer, pretty much, is what it is.
Yeah.
Specializing in geotech.
Okay, so that is the accurate term of art,
Yes,
geotechnical consult, okay. I mean, that's sort of what I'm asking, because I don't,
geotechnical engineer.
okay,
We use them in ISD all the time to analysis of soils of an addition or a home that's being built that, may not come up the specs for the inspector, so the inspector turns to the geotech to find out, is the soil able to support the structure or not?
okay. Ms. Weibel, I don't know, I think the draft that was in the packet's a geotechnical consultant. I don't know if it's supposed to be geotechnical engineer. But I just, and I defer to all of you, but I just want to make sure we use the right term.
Yeah, I
if that's
made a
what-
note of that. I think, Jonah, we can discuss it, maybe bring it back to Commissioner Morrison.
Yeah, I thought we had settled on geotechnical consultant being the technical term, but we can clean that up before, if this were to go out tonight, or if we were to come back to committee, we can clean it up.
Okay. President Albright, you all set?
I am. I want to be clear that I'm glad that we're finally getting that we're actually getting to this. I think it's a great place to be. I wonder if it doesn't need a few tweaks. That's all.
Thank you. Councilor Baker.
I hope I can be seen. I just sent you, Mr. Chairman, there's a short article in the American Bar Association about construction vibration, which we may share with the law department. It's speaking generally, but I think that I'm sympathetic to the concerns raised by the president about having some idea of what this means for adjacent property owners, because the issue has come up before. And one of the curiosities of this business is that blasting produces vibration, but is treated differently than other kinds of activities like pile driving. And part of the reason, as I understand it, is somewhat historical. Blasting had a history of throwing rocks at somebody, and in the old law that it was if you went across somebody's boundary, it was called a trespass. But if you were just causing vibrations in the earth, that was more called a nuisance. And so the distinction grew up, and matter of fact, Massachusetts used to have, and I don't know if it still does, a statute that says that there is some strict liability in these situations. So I think that it might benefit from having the law department look at it. If I can find that old statute, I'll dig it up. But I guess the point I wanted to get to is to ask a little clarification. I've got the ordinance here, that failure to comply in the sense of coming through a permit process that involves the assessment is an important piece of the puzzle. In other words, you don't want to just say that you've violated the ordinance. There's really a pre-approval aspect to this, which I think is really important in order to protect people. You need the pre and post assessment of the abutting properties, and that sets up this conversation, I think, that Councilor or President Albright is concerned about. So I'd support the idea of some sort of notice, at least to make sure that even if there is only a private remedy for the damages, that there's at least an awareness. Now, the ordinance talks about pre-construction review, so I assume there has to be some conversation, but it seems to me that might be thought through. And then the last question I have is, I think the president indicated there was an ordinance in Toronto, and Mr. Temple indicated this was new. Is this new to us, or is this new nationally?
This is new everywhere. I mean, there are very, very few instances. President Albright, maybe we found one in California as well. But there are very few instances of any regulation at a municipal level in this area.
You might say
Okay.
this is groundbreaking and could send shockwaves through the industry.
Mm,
Boo.
Sorry.
Councilor Baker, though, you did raise another point that I wanted to highlight, which is that this does not cover blasting at all. And that's because under Massachusetts state regulations, there's a whole separate oversight and review and requirements. And you have to get a permit from the local fire department before you can do blasting.
And I understand that, and I think maybe there's a value in having some disclaimer in the ordinance or associated with it, just so that people are looking around at vibration don't come to the assume that there's a blasting remedy involved in this. Just as a matter of clarity, I think.
Yeah, I would think if and when this gets enacted, ISD would have a subpage on their website with kind of more easily to digest information on how to comply, and maybe it would link or include the blasting information as well.
The last question I have, which is unrelated to construction itself, but there are situations where ongoing activity, because it produces vibration, is itself a problem. It's not necessarily construction related. It's just that sometimes people have machinery and other things that causes some difficulty for nearby properties. This doesn't cover that, as I read it, right? This is pre-construction and post-construction oriented.
Correct. I mean, it does require the plan for the vibration control plan probably will involve monitoring and setting set levels for max, vibratory impact during construction. But that's not
that part. But if we're talking about vibration annoying people during, as the day goes on, not related to construction, but somehow machinery operated, that's really a function of the noise ordinance, as I understand it. Like,
I guess, I guess you're saying machinery that's not related to the construction.
Yeah, I mean, if you put in some sort of unit, air conditioning unit, or some other unit that produces some collateral vibration next to a neighbor, this is the kind of thing I've heard of.
Oh yes, and the noise ordinance would play a role in that.
Yeah. Okay. I just think that, again, we're talking about trying to educate people about what piece covers what, and that's all I'm going to be sure about. Okay, I'm done.
Thank you. Councilor Greenberg.
Thank you, Chair. So Katie mentioned that this ordinance would be for both by right and land use special permit items, correct? Okay. So would the ordinance be triggered for by right by the ISD? When they see plans in front of them, they would say, okay, now we need to have vibration study done. Is that how that would work?
Yeah, I think so. 5-23A in the proposed ordinance says kind of specifies when this would need a closer look, and it's prior to demo or building permit for any demolition, site work, or construction activities that require 1, the driving of piles or piers, 2, the removal or alteration of ledge, or 3, soil reinforcement or compaction by vibratory roller, except for certain situations around landscaping, patios, decks, retaining walls, or accessory buildings under 700 square feet. So I would imagine when that type of construction is going on and being reviewed by building permit, the inspector would check for compliance. And I think Anthony could confirm that, if that's the understanding.
That is the understanding.
Yeah,
And so-
I would imagine that there'll be a box to check or something on the building permit applications as to whether or not you're doing any of those things.
Yes, we'll have to adjust the building permit application for that.
Okay. And for the special permit projects, would that condition be in every council order in case it's being triggered? Would we include it?
I
under
don't
the-
think we would need to. I think the ordinance would cover it. I think maybe we would need to maybe have something in the special permit application to kind of check the box, although the special permits will then go through a building permit application, so it would be caught at that stage anyway.
Oh, okay. So we wouldn't have to say it ahead of time like we do for the pest control or noise ordinance or,
Right, so I think it would take the land use committee out of the process, which, you know, should streamline things.
Yeah, and if I might add to that, I wonder if it would be similar to sort of how we treat the stormwater ordinance. We sort of flag it on larger projects, but they just need to comply regardless. So, you know, a single family home, we don't typically require them to have a drainage report at the special permit stage because it is so onerous and, you know, costly. But I think for this, you know, it would apply to all projects in the city. So even some single family homes, the land use committee sees this could govern those as well, depending on the construction type.
I guess I'm just thinking, for the abutters, if they know that that's part of our process and part of their protection, if they see that in the council order, that they may not know that's gonna happen if it's not in there somehow. You know, like we talk about, you know, we often have abutters who worry about rats and noise, and we can always point to the construction management plan and say, oh, look, this is being taken care of here and here. And they may also have concerns about vibration. So I'm just wondering if we can just put a sentence in the conditions that if this type of project would trigger, this developer would have to follow the new vibration ordinance or something like that.
That's definitely
think
something
that's-
we can consider.
Okay. And then, so the Sunrise project that happened over here in Newton Corner a couple of years ago, there was a lot of vibration problems with the butters. I don't know if you all recall that. And they were the company who was overseeing the vibration studies were giving the butters their reports weekly or monthly, I can't remember. And there were pages and pages and pages of technical. I mean, they would send it to us and I would have no idea. And, you know, some of the neighbors tried to refute them and rebut them, and they're very, very technical. So I don't know how useful it would be for abutters to get that kind of report from the developers. So I don't know.
Okay, thank you, Councilor
Thank
Greenberg.
you.
Councilor Humphrey?
Thank you. I was going to start by saying that as Councilor Albright had said earlier, it seems like notification is going to be key, but I think with the caveat just raised by Councilor Greenberg, which is that the notification also has to be comprehensible to, you know, an ordinary person. I think the notification really probably should focus on mostly like, hey, there's about to be a bunch of vibrations. Sorry about that, you know. I'm glad to see that we are working on this. I know certain areas of Upper Falls with a lot of Roxbury Pudding Stone Ledge and Oak Hill Park and some other places, there's been a lot of vibration and blasting and things even on really minor projects that were not special permit projects over the past 10 years. So it feels like it's overdue, although I guess it sounds like it's not overdue in the sense that almost no one has an ordinance like this. I guess what are we expecting if this or something very similar to this passes? What are we anticipating that the positive benefits would be that people would see in terms of nearby neighbors compared to the status quo situation? And I'm particularly interested in some of those smaller projects rather than the larger ones.
I mean, I believe that, you know, just having the ordinance and having it being able to, and let the abutters know that somebody is watching would be more than comforting, I think.
Yeah, I imagine the impact would be for those smaller projects, which absolutely can cause significant vibration, because in some ways it's not the size of the project, it's it's whether or not there's ledge or certain things you're doing. They're going to have to hire a geotechnical engineer to put a vibration control plan in place, which projects of that size probably aren't doing right now.
So that's what I was actually curious about as well for a smaller project like a single family or two family or something like that. And I'm not saying this is a bad thing. I'm just asking, is this likely to discourage them from doing some of that pretty intensive work with the drilling or blasting or whatever it is, jackhammering?
Anthony, I'm interested in your take, but I think it's a balance, right? That's why we really tried to tailor this to the type of work you're doing, not the size of the project. We had, this went through multiple iterations, and it's gone through multiple iterations as a special permit condition. And at first we were trying to not have it be triggered unless you were under, 35 units or something like that. But I think where we've come to is the size of the project is less relevant, but it's certainly for one family, it's going to be much more of a burden to comply, I guess.
Definitely.
Yeah, because I mean, I'm saying this is a matter of personal preference more than anything else, but like, it would not bother me, let's say, if there were not so many projects jackhammering out ledge to do a big single family tear down, because I just don't, it's like, that's not an appropriate place to build a huge basement, in my opinion. Are we anticipating any sort of downsides to this ordinance? I guess it could potentially have some effects on some of the larger projects, but it sounds like mostly the larger projects would just be, complying with it, doing some studies, et cetera, which, I think is relatively minimal compared to the scale of those things. But I think Councilor Albright had alluded to earlier that because this is relatively new area of law, there's pros and cons, is what you had heard from folks that have experience with them elsewhere. So I was kind of curious what some of the cons might be.
I mean, I think it was what you just hit on. From my mind, the two cons that come up are, a single family home that's doing a small addition, and they're not expecting it to be a big project, but because of where that addition is going, there's ledge there, or for whatever reason, they need to cause vibration. It's going to be a very significant added cost for them. I think the other con, and for us internally, is the added administrative burden. And we've tried to limit that by putting a lot of the onus of compliance on the homeowners. But there will be, some added administrative burden here as well.
Yeah, I was just kind of curious, like for the bigger projects, if we're anticipating this is going to have any sort of deterrent effect on, the number of units that gets built or something like that.
I don't think so. In my experience, from talking to the larger developers, they are doing this on their own for the big projects. They're going to do their pre-construction surveys to cover themselves and post-construction surveys, and they're going to do monitoring in most instances if they're driving piles for underground garages and things like that.
And Ms. Weevil, I think you had indicated in the revised language maybe that there was some sort of provision for smaller additions or ADUs or something like that. I think it was 700 square feet or something. Is that the number, and how did you land on that particular number as the cutoff point?
I think we landed on that because it aligns with the zoning. So accessory buildings are allowed as of right under 700 square feet with that footprint. So I think we're sort of trying to be consistent.
Now, colleagues and or staff, my recollection was the number was different for ADUs, though, when we passed the change to allow by right ADUs. So we might want to bring those into sync, because I could see a scenario in which you were, rolling out a concrete platform essentially for an ADU or something like that. And if that's, in the 800 square foot range or something, we might not want to have that become a whole thing from a policy standpoint.
I understood the footprint may still be limited, but the size of the ADU, across a story and a half can be larger. So it's more about the footprint, but it would also, that number is also there because, it also plays into lot coverage and open space and things like that. Anthony, I'm not sure if you have anything to add on the.
No, you're correct. I mean, you have a 700 footprint for a an accessory building, but you do have the half story above, which would contribute to the square footage of the building over the 700 square feet. So I think that's what you're asking.
Honestly, I don't, I'm not on the zoning or land use committee, so maybe I'm just not as familiar with exactly how the code works. So I can take your word for it if that's the case. I just want to make sure that whatever we're passing here is not undercutting the work that we did with that ADU reform, because I don't want people to be discouraged from doing a by right ADU because all of a sudden now they have to do a geotechnical thing that they weren't going to previously have to do. And it would probably be for some relatively minor work, I'm guessing, I would hope.
So
But as
it
long
does-
as long as we're taking a look at that, yeah.
I mean, there's
Sorry to-
always a
it does
chance of
look
that
like-
happening.
It
Mhm.
does look like the maximum for a by right detached ADU is 900 square feet, which is a little different than the 700 we're using.
Yeah, that was my off the top of my head recollection. And so that's a little concerning to me. I could be persuaded that there's that there's a rational argument for saying that we do need to watch out about the, vibrations associated with one of those. But we also know that there's this huge, rapidly growing market for prefabricated accessory dwelling units that come in a standard size. So the person's not able to really customize the size, and they're under that 900 square foot, footprint. But, I'm guessing they're not going to be doing blasting or jackhammering of ledge to do one of those things. And so I'm thinking more of, lesser sort of vibration issues, but I'm just flagging that now that I think we should make sure that those are in alignment.
Yeah, that's another thing we can add to our list to talk through internally.
Okay. And then I guess my last question for now is, let's say that we, pass this end of term, something like that, it goes into effect. Does that immediately apply to projects that are already under construction that previously had not been covered by any sort of vibration thing? Or is it that, if they're already in progress, it doesn't apply and it's only, ones that pull the permits after it goes into effect?
Yeah, that's a good question. And I actually think we need to add in an effective date and what the trigger will be in that regard.
Okay.
So that's something we can talk through. To me, we probably want to pick a date a month or a couple months out from when it's passed so that we can make sure people are aware of it. And it probably shouldn't apply if you've already applied for your building permit. So it would be like, it will be applicable to any project that has not applied for its building permit prior to, March 1, 2024 or something.
Okay. Thank you.
Councilor Humphrey, really good points. President Albright.
Thank you. I just wanted to be sure that so ask the question, I guess, that the post-construction survey, if damages are found, does that affect the ability to have an occupancy certificate?
Not as drafted. I mean, I think if damage is found, and I think the private remedy will take care of itself. I mean, the developer will hopefully take responsibility and pay for it, or the homeowner would be in a good position to seek a remedy on their own.
So the city is sort of hands off. If damage was caused, it's up to you to figure it out.
Just like any other damage caused during construction or not during construction.
Okay. The only I was trying to Google this, and it's probably I should have done it before the meeting, and I forgot to do it. But the issue of landmark and landmark buildings and historic district buildings. So if work next to one of those properties, I feel like there needs to be at least some mention of, that you should pay special attention for historic and landmark buildings, historic districts and landmark buildings.
Yeah.
And I would rather have some standard reference, but since I can't find it quickly, it feels
No,
like
I mean,
there should be some
I
mention.
assume, Chair, you're not planning to vote this out tonight. I mean, I know the end of the term is coming, but I think maybe letting us take these points back to our internal team and make any tweaks as needed makes sense.
Yeah, that definitely seems to be where we're headed.
Because I understand that concern, and maybe there's language we could come up with.
Okay, thank you very much. That's great.
Counselor Baker. Counselor Baker, are you there? All right, I'll come back to Counselor Baker. Counselor Greenberg? Counselor Greenberg, am I here?
Yeah, I'm here.
Okay.
Sorry, I couldn't find my button. Anyway, do you think it would make sense to include a radius or a scope of area butters that the vibration would affect?
So
In
that
the
was
ordinance.
exactly where we went wrong in land use. We picked a number of 250 feet, and some projects need more, some projects need a lot less. And that was kind of the impetus for this whole thing.
Okay.
And talking to Josh Morris, I mean, he said that number was crazy for any of his school projects. But maybe in certain circumstances it would make sense. So it's really putting it onto the geotechnical engineer to make that assessment as to what the scope should be.
Okay, thank you.
Okay, Counselor Baker, are you there now? Counselor Baker?
Hey, can you hear me? I'm
Yes.
trying to, oh, I'm sorry. I'm having trouble with this gadget. I would agree that with Councilor President Albright about historic properties. The point though, just to pick up, the ADUs are not automatically a problem, but they are close to the lot line. So that sometimes that's beneficial to have some review on that score. So I think that, if they're just putting on a slab, that's one thing, but if it's going to involve more work, it may be useful to have some oversight. But I think that the drafters can go back and look at that. But that's the only point I want to make. The proximity is sometimes greater.
I can guarantee you if it's gonna be a 700 square foot footprint, that they would need a frost wall foundation, so they would be digging. Not on a slab.
Okay, I think it's worth having that included.
Okay, so I think we've identified some issues that I think we all agree just need to be straightened out, require maybe some recommendations. I wasn't taking notes, I don't have them all written down, but Jonah, Katie, I think you can probably work with Jacqueline to get a good summary of what those are if you didn't get them. And then we can plan to meet again. I know we have at least one meeting in November. And maybe revisit it then.
That makes sense.
Okay. Okay, does anyone have anything else before we presumably hold these items?
Can I move hold on both?
Counselor Humphrey has moved hold. Any discussion? All right, all those in favor of hold, please say aye.
Aye.
Any opposed? Any abstentions? Okay. I think we're going to try, I think, and finish up the tree ordinance probably at our next meeting. I know Mr. Temple is good enough to look over the drafting of the ordinance. As I said, earlier in this meeting, we want to get a look at the ordinance before we finalize it out of committee, make sure it reflects all the decisions that we made. We'll try to do that at the first meeting in November. I want to say that's November 8th.
Yep.
Okay. And that should be relatively quick. I mean, it should be just sort of does this line up with what we've already decided, not necessarily an opportunity to revisit all the issues. So I would think that on that night, we should also have time to review this ordinance as well. Does that seem to work for committee members? Okay.
Yeah.
Then I think that'll be our plan. Jacqueline, that'll be our plan. And
Sorry, Chair, just to interject. That sounds like a good plan, but I have a somewhat concern about us being able to work through all of these issues before then. We'll do our best, but I assume that your next meeting in November would be available too.
Yes, I don't. I just don't have my calendar in front of me. Jacqueline, do we have another meeting in November?
So
Or is it
historically,
just Thanksgiving get in the way?
historically, that meeting is canceled as is the day before Thanksgiving.
And then there's one more meeting in December.
Yes.
All right. Well, we will aim for November 8th.
Okay, or Jonah, you and I can get together the night before Thanksgiving and talk about, vibrations. I think that would probably be. We'll see. All right. Thank you all very much again. Thanks everyone for your work on this. Really appreciate it. And we'll visit this again in November.
Thank you.
Okay. Have a good night, everyone.
Good night.
Good night.